Hi everyone, hello. You're welcome to this webinar where we'll be talking on intellectual property basics for startups in the light of developing an effective intellectual property strategy. So we'll start off in just a bit. Let me just turn on my video. Okay. So today we have some experts that will be talking to us on the topic intellectual property and startups, and we'd like to meet you. So first we have Augusta. Augusta, can you tell us hi? Can we hear your voice?
Good afternoon, everyone. My name is Augusta Geabi. I'm an analyst at Tech Hive Advisory. You want to know title?
That's right. Okay, so next up we have Rita. Rita, can we hear your sis voice?
Hi everyone, good afternoon. My name is Rita Amrichinda. I am an intellectual property lawyer and a podcast host. Happy to be here.
Okay, we're happy to have you as well, Rita. So before I start, I didn't tell you guys my name. My name is Sabia, and I'll be moderating this session. I'll be moderating this session. So firstly, in order to kick off the session and just make everywhere easy, we're going to ask Rita what IP is. What do you think IP is? Everybody's saying IP. Can you just us what IP is?
Okay. First of, IP is a combination of both creative works and innovative work that gives the authors the exclusive rights to commercialize their creativity and invention. That way, they are legally backed by the law and protected in the jurisdiction they are based in or they've expanded their business to.
Okay, thank you. Augusta, do you have anything to add to what Rita said? If you're talking, Augusta, you're mute. We can't hear you. Yeah, that's right.
Just to add to that, IP is an intangible right. So what that means is that it does not diminish, so to say, by a person's use of it. So for instance, if I write a book, if Xavier buys the book that I wrote and Rita buys the same book, their use of one book does not affect the next person's use of the same book, and I still retain the rights, so to say, of the book as a whole. So even if Xavier and Rita would have the property rights of the book, the physical copy of that book, I retain the IP rights. That's the copyright.
Okay. So one key thing I'd like to take from Rita is, registering your intellectual property basically gives you that exclusive right to the particular type of IP that you're registering. And for OG, that is, IP doesn't diminish. It doesn't just come today and then go away. So next up, we're talking about intellectual property and startups, and would also obviously like to know, the importance that IP plays to startups, and in that, to that end, right? What are the most relevant types of, IPs that startup founders should take note of? Rita, can you help us answer the question?
Okay. First up, from the production stage, when the idea is being had, because that IP doesn't protect ideas. So when you start putting in the vision and trying to put your startup together, from that very moment, there's an intellectual property created. It could be a form of copyright, which protects literary artistic works. So your sketches, your software codes, your objects and object codes can be protected as well. The name of your startups gives you trademark protection. So the name, logo, slogan, symbol, colors can be trademarks. Then if you're also going into product creation, you're going to be making something, you have to consider design rightly protects like the visual appearance and the combination of lines and colors of your product. Then if your startup is solving an issue in the society, then you also have to consider patent rights. Now, there's another form of IP that people take for granted, which is trade secret. So any confidential information or any information that gives you anything that gives you an edge in the tech space is a trade secret, and we don't take it seriously. So from the people that have access to information about your startup, about the project, about the products itself, just basically anything. Those are relevant IPs that one can consider as startup. But from the very moment that you start thinking of, oh, I want to be a startup company, you have to consider IP up until where you get into the marketing stage where you have to put that content out there. You have to do your IP to diligence to verify that there's no infringement on any existing IP, so that you don't have lawsuits knocking at your door when you're just starting up.
Okay, so I'm guessing, Rita, you're done answering the question because my network sort of tripped for a bit. If you're talking, you're mute because we can't hear you.
I'm done. I don't know if every other person heard me, but I kind of said a lot.
Yeah,
talking
you
about
did.
how IP is very important from the very moment you consider idea, and then the types of IP that are relevant to this the startup industry, software, name, invention, appearance of the products, and also confidential information or that thing that gives you an edge in the tech space or in the startup space, so that you know that it's not existing anywhere. And another thing is that IP is territorial, so you have to verify that it's not existing in Nigeria first of all, because I'm thinking about the international space. And there are also, other requirements and criteria that each of these intellectual property mechanisms require. For instance, for trademark is required that the name, logo, slogan are distinctive enough. For design and patent, it has to be new, novel, not just to a skilled person. What that basically means is anyone in the startup space, if he sees it, they cannot reproduce the exact work that you did. So
Yeah.
there is not impose any moral or public policy out there.
Okay, like indeed, like truly, you said it was because I was already beginning to. I mean, you already even asked me the next question, which is like, when should they start up? Yeah, start considering intellectual property registration and all of that. So for us not to leave OG out, do you have any other things to add to like the types of IPs that are relevant to startups, like the major types?
I think Rita already outlined the important ones: copyright, trademark, patents, and trade secrets, industrial design. But I think you also asked why it's important, why IP is important to startups. Was that part of the question?
Yeah, why it is relevant to startups. Yeah.
Okay, so one of the key things for a startup is that IP contributes to your valuation. So it makes up the total assets of your company. So when investors are looking to invest in your company or acquire your business, your IP assets are the type of things that they will look at. They will look at whether you've registered the assets, the commercialization opportunities that you have for the IP that you have, and just what the structure is, if you have a strategy, things like that. So that's why it's very relevant. It also helps you to differentiate your business from competitors and to increase your market share and revenue in the future. So yeah.
Okay, I like the way you're just saying market share, revenue, you're just giving it to us. Like it's even part of one of the questions that we're going to deal with later today. So when should a startup start considering IP registration and protection? So Rita already told us, like as soon as your business idea comes into place, as soon as your business idea just falls through, that's when you should start considering
Yeah,
registration of
can
your
I
IP? Yeah, you can, sure.
can I add something? So another thing that is part of it to consider in terms of registering or when you should register their IPs, the kind of IP system that applies in that jurisdiction. So for instance, in Nigeria, we apply the first to file. So if I file any IP before you, I'm considered to be the owner of that IP. Whereas in jurisdiction like the US and the UK, they apply the first to use principle. So if a startup started using a particular IP without having registered it, it's considered that he owns that IP. But registering the IP gives you backing and also identifies you as the owner and gives you the exclusive right to use them for commercial purposes.
Okay. So yeah, it is not just enough, to like have that idea, try and register, because if I have an idea and Rita has that same idea and she literally, registers before me, she's gonna get all that money. That's not gonna be fair to me. So yeah, the next question. So I mean, we've been talking about IT this, IT that, and from Rita's, explanation on the types of IPs that are relevant to startups, she made some sort of examples, like for sketches, softwares, and programs, they fall under copyright. So, but then how, as a startup founder, as a business owner, right? How do I know what to protect? What assets are important? What exactly is it? Just, oh, my idea, I just register just like that. What exactly, so that we don't just say, oh, okay, register IP, but we actually don't know what exact IP that we're registering. Oji, would you like to take this for us?
Okay, so first off, like Rita already said, you have to have an understanding of the different types of IP and the possible benefits they would have to your business. So if you know what a trademark is, if you know what a copyright is, a patent is, or what qualifies as a patent, what could qualify as an industrial design, or what could be a trade secret for your business, you would know how to identify them when you eventually create them in the course of business. Another thing to look out for when you are trying to decide what to protect, that's like what to register, especially if you have a small budget, is to create a priority list. So basically, what this is going to be is like you would list out the possible assets you have, based on a scale of preference. So that would be the ones that would give your company more competitive advantage, the ones that would be very detrimental if you do not protect it. For instance, I create maybe smart glasses and I don't protect it. Neither do I use NDAs to make sure that people who have access to the technology behind the glasses don't talk about it. So when I don't protect it and my competitor, maybe Savia, she makes similar things to me, she now gets a hold on the new technology I've created. When she starts to manufacture it and to sell it, it would be detrimental to my business because that would reduce my market share because she now has a better product than what I previously did. So you grade your assets based on what would be more important to your business, what could increase your revenue significantly, and what would affect you if you do not protect it. So when you rate it based on that scale, you can see what to protect first before the others.
Okay. So basically you're telling us like, as a startup founder, as a business owner, you need to just have that scale of preference and, pay more attention to the assets that would significantly impact your business. All right. So, I mean, OG has been giving us investor vibes, and we're coming to the question. We're coming to the investment question finally. And I mean, right, most people say this thing that, for example, now trademarks for a business, usually increases the valuation of their company, of their businesses, right? But it's not just enough for you to just say, oh, I have trademarks, it's increasing my value. How can you actually show it to your investors? And, what will make them, see your company worth $50 million, for example, rather than probably $10 million without the trademark? That's just an example. OJ, I'm seeing your eyes open when I just said money. Anyway, so let's just go to the question. The question says, so like, what are the advantages, disadvantages of having registered IP assets when looking for funding, when you're sourcing for investments from various investors. Can you help us with that, Rita?
Okay. First off, you know that, okay, I had stated that when you have an IP, you have to use it for commercial purpose. And that way, you're able to generate revenue for your business when you license an element of your products, or you assign your rights, or you go into partnerships or collaboration with third parties. So you don't just discard any of your product or elements of your startup because you feel, well, that's not financially inclined, it's not going to generate revenue for you. And doing that gives you like an edge in the market. Then documenting it by registering or protecting it in the jurisdiction that you're based in. Then having like a long-term goal whereby whereby you choose the jurisdiction that you wish to expand to, and then you can then consider the available regional IP systems that you can register. So if you want to register in different speaking African countries, you opt for their own registration, or you opt for the foreign IP systems. Then it also gives you leverage and identity as as the owner in the event of a dispute. You're able to show proof and documentation that you actually own that work when you registered it. And then again, when you don't register it, for instance, trademark gives you, like, when you don't register your trademark, it gives you limited protection in your jurisdiction, or generally where you can sue for passing off, and you have to show proof that your startup goodwill or reputation has been damaged, what you've lost so far as a result of that. Apologies. For design writer as well, you also have like a limited timeline as to when you can regularize your registration. You have 6 months to do that. While for patent is one of the delicate IPs, because disclosure, when you disclose to the public, your work is not considered new. So those are things that you need to take into consideration when you decide that, oh, this is what I really want to do as a startup. I hope that answers your question, anyways.
Yeah, it does. So do you have anything to add to what Rita said?
Rita gave a very in-depth explanation of the advantages for registering, so commercialization, expansion, proper protection from infringement. So I'll just add that when you register your IP and maybe you're looking for funding, it's able to increase investor confidence, because like I said before, it makes your IP assets make up the valuation of your company, contributes to the valuation of your company. So it can, when you have a good IP portfolio or a strong strategy on how you register, how you manage, and how you commercialize your IP assets, when investors see this, it makes your business look more credible. There are more opportunities to commercialize in the future and things like that. So when you register your IP, it's increasing investors' confidence and lets them know that it's a credible business they are going to invest in.
Mm-hmm.
Yeah.
Okay. I mean, so it's not just enough to have that idea. I mean, if you're a startup founder, if you're somebody with a novel idea that, wants to start up a business in the coming years, it's not just enough for you to have that idea. It's very important for you to also look forward to registering it, because if you're registered, no one else is going to help you and register it, and they're not going to share the money with you. So let's go on. So for businesses, for startup, founders, this question is for you, OG. Do you have like any tips that businesses can, use in order for them to create an effective IP strategy? Things that they can just, take note of.
Okay, so like Rita pointed out before, trade secrets are very important, especially to startups. It's not everything that you can protect. It's not everything that you can register and protect, so to say. So when you're drafting your IP strategy, it's important to outline how you're going to protect confidential information. So NDAs, the procedure for signing the NDAs, is it before the conversation? Is it at the point where you initialize conversation, maybe with investors or with possible collaborators and partners? When you when you collaborate with third parties, so you have to make sure you outline how you handle confidential information. Another thing to include in your IP strategy is how you would handle third party rights. So, when you create a startup, you're not the only person that's going to be running it. There are different parts. So you are going to employ people, obviously. And your employees could create possible IP assets for your company. When you employ them, your strategy should include things like assignment clauses in their employment contract, which would mean that when they create whatever they create, it would be assigned to your company, and you would be the one to have the rights. The company would be the one to have the rights to that creation. So things like that. When you contract independent contractors, let's say a graphic designer, and the graphic designer creates a new logo for your company, because if we're going by the normal way I am copyright law works, the designer is the owner of that logo that he created for you. But if you include that, the work will be assigned to you and is created, you include a clause that explicitly states that the creation or the result of this contract will be assigned to your company, then you are safer. So your strategy should include things like how you would handle third-party assets that are created and how you would handle confidential information. So just some things. There are other things to put, but those two off the top of my head.
All right. Rita, do you have anything to add to OG's? Why are you laughing? Okay, I can't hear you anyway. It's because you're muted.
Yeah, no, I think Oji has covered everything. She basically said what I would have said. But yeah, documentation, signing the relevant agreement, and also stating who owns what, percentage, if the joint authorship, and the rest of it is very important that we put that out there. So I'm just going to so there's this, I think it's a South African case. I talk about it a lot. It's about the please call me short code. He was an employee who actually created that while he was working for Vodacom, and he even informed them about it, and they went into like a licensing arrangement. But because no one actually saw the future that it was going to blow, they decided to go back on their words, and apparently they've been in court for over 25 years and still yet to resolve their case. So sometimes you might have that great idea as an employee, and you decide to commercialize it because you can't really trust people on their words. Sometimes you sign an agreement and someone decides to breach it, and then there's a dispute, and then you're in courts, or you're opting for alternative dispute resolution mechanisms such as arbitration, which is mostly used for commercial dispute or for mediation or negotiation or expert validation, whatever it is. And then you're going back and forth, and it's like you're not really making so much at the end of the day. So I think that's basically answered it, but Oji said a lot, and that answered the question.
So I mean, from what you both have said, right? I want to pick NDAs. NDAs are actually very important, and that's why you see like companies like Coca-Cola, for instance, right? Definitely, they have a trade secret. They have that. There's some mixture. That's why Coke can never be like Pepsi. I don't know those of you that are drinking Pepsi. I don't know what they are drinking, but those two things can never be the same because definitely they have like different mixtures and stuff like that. And the people actually making them, right? Definitely they'll sign NDAs that you can't leave, you can't do certain things at certain periods, even if you're going to leave the company and stuff. So yeah, as startup founders with novel ideas, it's very important to have NDAs and very other important contracts. So the penultimate question for this afternoon is going to be, I mean, for a startup that's just starting out, obviously the startup, yeah. So it's just the startup is just trying to create their business. Obviously, they have operational activities to sort out, administrative work to do. How can a startup handle all these things, side by side with also handling intellectual property? Oji.
Sorry, can you repeat your question? I think Sylvia. Rita, can you hear me?
Yeah, I can hear you, but I can't hear her.
Okay, I think it's from Sylvia's end. All right. Sorry everyone. Sylvia will be joining us in a minute. She has some technical difficulties.
Sorry, I don't know, my system, I don't know, had an issue with the network, so I had to like use my phone. Am I audible? All right. So I was basically saying that I was asking about, I was saying that startup as a new business, you obviously have to, your main aim in most cases is to make profits, and you have some managerial administrative activities to also, cater for. So as a startup founder, right, how can you handle intellectual property in all of these?
Well, like you said, there's a lot to do when you run a startup. And
Okay.
because IP is a very critical aspect of your business, and if not handled well, could lead to a loss in the long run, it's advisable to employ or to consult an IP expert to help you handle your IP. So in the drafting of your strategy, when you're talking about how you want to manage it, commercialization opportunities, things like that, registration, consult an expert, someone who actually knows what they're doing about it. But at the same time, you have to make sure that the expert you are consulting for your business is a good fit for it. And when I say good fit, I mean that the person should understand if the core technology of your business, like the person should know that, okay, so this is a loaning app, this is how it works. They should understand the technology itself, and they should also know the goals for your business. So that's what I would qualify as a good fit. So, but if you're talking about managing your IP as a startup, please consult an expert.
Okay. Rita, do you have any words to add to what Oji said?
I guess what I would just say, other than having an expert, is like having the right team and curtailing who has access to whatever information that will be shared. So the team could comprise of, the founders, the lawyers, and maybe one or two other staffs, and then that way you're able to manage information, you're able to decide on what you can share and not what you can't share. You also need to consider platforms for communications that will be using. You also need to track your documentation, make sure that you've carried out your IP due diligence, and just like she had said, have a lawyer versed in IP or has an idea of how IP interplays with startups and tech, or the industry which the startup is going to be focusing on. That way, it's easier for you to do your compliance, to do your registrations, and every other thing that comes with starting up a company, basically.
Okay, that's great. I mean, from what you both have said, right? It's not just enough to just get a lawyer. It's not enough to get the law. Don't just get any lawyer, right? Because you want to get somebody to draft your agreements, get somebody that actually understands the process of what you do, of your idea generally. So finally, I mean, there are some startup founders here as well, and also people that probably want to, you know, create a business in the nearest future, right? And would just like to know, you know, what are the common mistakes that startups usually make when it comes to intellectual properties, and you know, like, yeah, like what can they do? What are the mistakes so that we shall know that me, I want to be a business owner one day. So just let us know, yeah, the common mistakes that startups make when it comes to IP, and how we can avoid them, or how can all of us can avoid them. OG, can you answer this question? And then Rita, you can, you know, take over from her when she's done.
I think a major mistake that many startup founders make is that when they create something that can ideally be protected by patents, they disclose the information to the public before it's registered. So one of the requirements for patents is that your invention must be new. So an invention is like a new product or an improvement on an old product, like that smart glasses I said before. So when I tweak it, I create something new, or I can now translate languages with my glasses. Google actually has glasses like that. So let's say instead of just maybe reading signs or whatever, I create glasses that can translate languages in real time. And then I don't protect that information. I don't register it as a patent, and I start disclosing it to investors. I start going for seminars and just talking to people. We'll see this new stuff I made. Or my glasses can read. They can read languages in real time, can translate languages in real time, and I start explaining the technicalities of that of the technology before protecting it. That might negatively affect my chances of successfully protecting my patent, because, like I said before, to protect a patent, your invention must be new, and when you start publishing it to the public, start telling people about it, that could affect, the newness, so to say, of your invention. And at the same time, your competitors could take advantage of that opportunity and increase their market share to your detriment. So please, before you start telling people about your inventions, make sure you have consulted an expert or have registered it. Another thing you can do when you are maybe trying to get financing from investors, so you would have to tell them, some things about what you have created and how that would how the possible financial benefits to them. It's important that you make sure they sign an NDA. So anybody that's going to hear about this new creation that you intend to patent, they have to sign NDAs before you speak about it. Because, like I said, it could hurt your chances of registering it in the future.
Okay, Rita, you can go next.
Okay. I think for me, one of the biggest mistake is not consulting. Consultation goes a long way to help a startup. So that way you're able to prioritize the IP that is really important for your brand. You also do your search and investigation as to, the products, if it's going to bring in investors or give you consumers a model to apply and the rest of it. However, in an event where a startup, because I see this happen when people are like, oh, before I have a different opinion, anyway, that's just my opinion. Where people are like, oh, before you go to get funding or you're talking to a prospective funder, ask them to sign an NDA. I always oppose that. I'd rather you register that IP than try to coerce someone into signing an agreement that they may not honor at the end of the day. So we've seen live cases where an NDA wasn't really signed, but parties had gone to propose or share confidential information about their business in the hoping that they were going to get the brief, and they never got the brief, and instead they ended up going to reproduce the exact thing. So two cases come to mind: is the Ford car wiper and the recent Meta case against Boxer, where they had to share patent technology of how the live streaming came about, and they ended up, now they are smiling at the end of the day because they won in court. But let's look at it from the point where they did not win in court. What would the story be? It will turn out to be like a Goliath against David. As a startup, or a business owner, just do the basic. If it's copyright, or deposit a copy of your software or the sketches with the Nigerian Copyright Commission. Do so. If you're going to trademark, pick the most important trademark in the class that applies to your business, and then have a long-term goal of doing multiple registrations. I know when Amazon started, they didn't have so much trademarks out there, but I know as of 2 years ago they had about 1,000 and counting. I also know someone has about 4,200 patents that he licenses to different people. So going into like a non-exclusive registration license arrangement can generate revenue for you. Like when you go into an exclusive registration, you can also have a long-term goal of creating like a franchise from your brand. So when I have conversations with startup founders or business owners, my question is always, what is your long-term goal for your brand? Are you doing it as a side hustle, or do you see your product as an intangible asset that can give you long-term returns at the end of the day? You don't rush it. You have to ease into it. That way, no one takes advantage of it. You also need to have it at the back of your mind that this will definitely arise between your co-founders or your staff. So have this resolution policy and mechanisms that you can explore. Also have like a trade secret policy that your employees should be aware of. It's very important. It's not something that is very common in Nigeria, but outside like the US and the UK, you have companies who have trade secret policies. They have intellectual property policies that founders or employees or brand owners can opt for. I think that's basically from my end, I guess. Maybe if I remember any other one, I'll just talk about it.
Yeah, that was good. So I mean, before we, finally close the session, if you have questions, you can just, send them in. Pending that time, we have one question, and I'll just read it out, and either of Rita or Oji or both can go, ahead to answer it. So the question says, please expatiate more on the types of IP systems. Okay, I'm guessing the person is meaning types of IP, types of IP, industrial design, and patents. So that's the question. Does anyone want to help us?
Let me just for IP system, I would say figure out what's your jurisdiction, what the IP laws are when it comes to your jurisdiction, what it takes to register your IP at the end of the day. Like I talked about, the local registration, the regional registration, and also the international registration. That's what I think the person is asking about. So locally, IP, because IP is territorial, it's very important that it starts within your home. So if you're based in Nigeria, make sure that you do your registrations with the necessary trademark registry, necessary IP registries, whether it's the trademark, the patent or design, or the copyright commission, whichever it is. If it's regional as well, find out what ARIPO and OAPI requires. I know Nigeria is not a signatory or member state of any of these regional. It might cost you a lot more. And also, if you're doing international registration using the WIPO system as well, that may also cost you. On the treaties that Nigerians are signatory to, that might give you an edge as to the fact that you may not spend so much. Then answering your questions as to design right. Design right protects, like I said, the visual appearance of a product. So how the car looks, how the chair looks, how the AC looks, combination of line and colors, black, white, red, whatever it is, your logo as well, textile, if you're also into the textile industry, just all of that. Then for patents, patent protects inventions, the functionality of that invention, what makes your invention unique and new and different and novel from every other AC or cars out there, or the Samsung phone, or the software powering Google or any other platform out there, or your UI UX applications. That's the function, or that's what patent does. The functionality basically how that invention works, what it's solving. How people used to iron before, how it evolved, and you find out that with tech, there's always a new invention. So it's not going to remain, the design is not going to remain static, or the invention will remain static. It's going to evolve and keep evolving. So as that is happening, you also have to evolve with time. Now you're talking about IP in the metaverse and Web3 and NFT and the rest of them. You're transitioning from analog to virtual rights or digital rights at the end of this. So these are things that if you consult with your IP lawyer, your able to get the right information. And Daphne just joined us. She had a meeting earlier, so she has everything she can just add as well. Hi, Daphne.
Hi everyone. So good to be here. Apologies for joining late.
That's fine. That's fine. We're happy to see you. You're shining.
Thank you.
Okay, so we'll just go over some of the questions that we've asked OG and Rita previously, just to get a sense of your view on it. And so IPs, right? Let's not even go to IPs. Let's talk about a startup, right? So for instance, right, I know that a startup's main aim in most cases, apart from aiming to offer a service, right, is also they also have so many other expectations, some managerial roles that they have to play and all that stuff. So in light of all this, trying to make money, make ends meet, how can a startup also handle intellectual property by the side?
Thank you for that question. So, good thing you said, like a startup, there's so many roles involved, and one is the legal aspect. So I think for every startup, it's important to identify what are your intangible assets, what innovation or what creation do you have that you need to use IP to protect. Because one of the things that would, let me say, add to the economic value of a startup would be the IP assets. So it's very important for them to have an IP portfolio. So, and that will start with first identifying what asset, like I said, what do they need to get IP protection over? How do they acquire this protection? How do they manage? Would they need renewal from time to time or maintenance? And because if for any reason they have to, do an M&A or do a licensing, these are like what will come into place, like IP audits and basically what is the economic value of that startup. So it's not something to brush by the side. I think that a lot of the time most startups just tend to focus on maybe financial aspects, but forgetting that their IP portfolio would add to even their economic value.
Okay. So yeah, I mean, I do like that you said, some startups rather usually just toss IP to the side. And actually, it's actually one of the common mistakes that startup founders make. They focus on the financial aspect. It's okay, it's good for you to make money, but don't try and run away from the main reason why you're even in business in the first place. So
Exactly.
also, yeah, I would also like to ask, the main aim for this webinar is, is in light of, enlightening startups on how to develop an effective IP strategy. So what tips can you give our startup founders on, ways of developing an effective IP strategy?
So one will be understand understand what IP, so we have different types of IP, and I'm very sure that maybe Rita and others have spoken about it. And so the first thing will be so like you said, why are you in business? And do you have some innovation? Do you have like your unique business name, like a source identifier, or do you have some creations that you think or you feel should be protected under IP? And then I like to say this because I feel like they always have to engage a lawyer because then again you have to like figure out what protection will cover. Is it coming under copyright? Is it trademark? Is it patent? Is it designs? Or it could be, a combination of both, right? And for some people, like I said, a startup might not have money, to seek diverse protections. And this is where, speaking to a lawyer comes in place, because what are the priorities? Because in doing an effective IP strategy, you need to understand what are the priorities, what is your project plan? And as such, in identifying your project plan, what do you think? Of course, everyone is important, like every aspect. Which should you start with? Which of the IP framework should you start with, right? And which one can you, take after finishing one cycle? And when you are able to identify that, right, the next thing will be, is it one that requires registration? Or so, for example, if you even have a trade secret where there's no registration, how well do you need to protect it? By having like a NDA for maybe your employees or people that are working with you. That's a non-disclosure agreement. So those are the questions you have to, ask. And if it's one that requires registration, of course, it will be to acquire the registration with the relevant government body. And this is where we talk about IP portfolios, right? Because it's important to have like a docket in cases where you have multiple, works or different type of layers of protection. You need to like have a docket where you manage it. So if you have a patent over this innovation, if you have a copyright, what are the details, and checking, because sometimes even the trademark might need a renewal after, like, of course, we definitely need a renewal. Maybe after the first time is 7 years. If you're talking about a patent, right, do you need to file like maintenance? So these are like the items that you would have to have in your docket system, and that's what you call managing. It grows from time to time. As your business is expanding and as it's growing, you expect your IP value to also grow and increase over time. So when you have that's like a docket system, which I think is the best strategy, you then know how to monitor. And like I said, I understand the budget of a startup, right? And that's why it's important to know which are you taking first. I have worked with clients who will say, oh, at this point, we don't need a copyright and a trademark protection, but we have a certain amount of budget. So we figure out, based on where your business goes and looking at your goals in the next like 2 to 3 years, right? Which is the first step, which is more important? And then we take off that one. Okay, let's go with trademark first. After the trademark, we'll then pull in resources for the copyright registration. And that's how it works, really. There's no like kind of fast rule about it.
Okay, that's nice. I mean, the whole priorities thing, it actually even falls in line with what Oji said earlier, like having a scale of preference, and then you can attack, each point on that scale as your budget deems fit and as your business grows from time to time. So we're going to take the second question, which says, and I think Oji, I think this question may be for you because you're the one that made mention of market share. But I mean, our other speakers can as well, chip into this question. So it says, what does market share mean in intellectual property?
So when I say market share, there's no special IP definition. It's usual business definition of a market share, which is your total percentage of revenue or sales that a business generates in the industry. So that's what I mean by market share. Like, Dangote, you could say Dangote is a leader, it's a market share leader in the cement industry in Nigeria. Yeah. So there's no IP definition, is the normal market share. I mean, like, how much are you selling? What's your customer base like? Things like that. That's what I mean by market share.
All right. Thank you. So the next question says, I'd like to ask, for media programs like Lion's Den, where potential startup founders publicly display their not yet established products to seek funding from potential investors, what type of IP protection is open to them, especially if it's a novel invention, taking into consideration that they may not be able to afford patent protection? Did we get the question?
Yes, I did. Can I go?
Okay. Yes, you can.
So I think I talked about it in passing, right? When I mentioned non-disclosure agreement, which is an NDA. And so we know that some startup, right, because of finance purpose, they might need to get investors, and so they want to market their product. Before you disclose your innovation or the product to any investor, it's important to have a non-disclosure agreement. So what that does is to bind, the investors to, okay, these are like my confidential, my proprietary interests, and sometimes, not just generic non-disclosure agreement. You could even list out, although you put a generic clause about for every IP protection not listed, and you could even list what you have, like the products in question. And it's very important to have that clause in your NDA that says that you, as the owner, will retain all the IP rights over this product and ownership, and that by you, maybe for the purpose of your NDA, divulging information does not intend or does not mean that you want to convey ownership of those rights to the investors. So when you bind them to such agreement and they sign it, it's like saying, so you sort of like safeguard your innovation. And if any like theft occur, you could use that, if you have to go into the dispute resolution or having a lawyer to come in and settle any issue, that's the first thing to rely on, the NDA agreement, right? Because that's in my own opinion, that would be the first step, right? If for any reason you're not able to. But there are some instances where, like I said, so it depends on what innovation is, right? And depending on what the cost is. There's sometimes that will tell you maybe you should just start like a one-step in your short process, if possible. If you notice that information is such that that innovation is very critical to the business, extremely critical, and you feel like you don't want to take chances at all, then you might say, okay, let's start like some registration, at least something to hold on to. But best and by and large, I think that the NDA would work in helping them protect. I'm sure Rita and OJ can speak more.
Yeah. Rita and OJ, do you have anything to add?
Okay. Yes. Yeah. So for reality TV show like Lions Den, which is kind of similar to the British TV show, what's it called now, Dragons Den. So if you watched both Lions Den and Dragons Den, you see that I haven't seen any of the Lions Den episode, but I know in some of the Dragons Den episode, some of the investors ask you questions as to whether you've registered your IP, you assigned it, or if you licensed to know that or if you registered it or not. So before you decide to go into those kind of events, read what the terms and condition is. So basically just read the terms and conditions of the TV show. Understand that in that event, a non-disclosure agreement may not necessarily save you because you're in there to get money. And whatever you signed before going on to the live show is what that will bind your relationship with the investors. I feel the Lions Den reality show should, have a lawyer educate the investors as to the importance of IP for startups. And going to a live show is basically you just doing what is called public disclosure, of telling people what your product is about. Someone else who is an audience can watch it and decide to replicate the same thing. And like I had earlier said that we apply the first to file system where you have not registered it. It takes, someone already is going to do that ahead of you, and then you come up, the only proof of documentation is that you were on a live show and you talked about it. So having also opting for a multi-layered IP protection will help you in that instance as well. So that you do a trademark registration or a copyright registration or a design registration or a patent registration. It all depends on what you have. It's also very important that you protect from cyber squatters or people that want to take advantage of the fact that you're not well informed. So for reality TV, read your terms and conditions, consult with your lawyer, decide if that's what you really want for your business. I always say, instead of looking for such opportunities, why not use and grow, register your IP. So when you can tell them you've done an IC valuation about your company, and this is what your company is worth. So I'm willing to give you XYZ in exchange for XYZ percentage of the company, and we do the order. And then you also have to show. So if I'm an investor, I'm looking for someone that is thinking like a business person. Other than looking for my money, what have you done to actually commercialize your invention, your product out there? Have you collaborated with somebody, whether is an exclusive one or non-exclusive? Which elements of your business can be licensed? So what is that big proposal around IP that you have for this? That shows me that this person is a very serious person. I'm willing to take a lot more than what you're even asking for. Probably other than God to do to meet other people in the industry. Bigger platform as well. So for viewers of Lions, they also come up Kenya, I think. So Dragon then gives you more insight. I know the UK has an exclusive blog that highlights some of the participants then that have IP elements that they can work on. So other than the rest of your IP company, but she had in the agreement she signed with her previous investor, she did not own any part of her name, the invention, logo. So while you're going on the live show, make sure the CTV still gives you some sort of leverage as an IP owner when you go to ask for money or funding. Right? That's IPC. I didn't do a podcast or blog about it. I just do like a daily write-up on Instagram.
Okay. Oji, do you have anything to add to what Rita said?
I think Rita and Daphne have properly addressed the question. So if you're in a situation where you can't make the investor sign NDAs like a live show, you have to make sure that you have preferably protected your inventions, patents, trademarks, everything, because it's a big risk just putting out your invention that has been unprotected on a show where anyone could essentially copy it, especially if you're going to disclose trade secrets. So maybe if you come and say, I make scented candles and there's a special way I blend them or whatever, don't disclose the way you blend it. You get? So even if you're going to display your products, try not to disclose trade secrets, because once it's out, it's out. So if you can't get a patent, protect it as a trade secret if you're going on a live show. And if you want to take the risk, then by all means, but it's advisable to protect your IP assets first before going on the show.
Okay, so there's a last question here, but before I take it, our three amiable experts, please just prepare your last words for our startup founders and business owners. So this question is deliberately for Rita. Please listen. You mentioned that the doctrine of first use does not apply in Nigeria. How do you reconcile this with the provisions, the law? How do you reconcile this with provisions of Section 8 of the TMA, that's the Trademarks Act, which seeks to protect persons who have used a brand name prior to registration by another person? That is subsequent registration. Rita, did you get the question? Are you there, Rita? If you're speaking, you're muted. Okay, so before Rita comes up to answer that question, does any of our speakers want to shed more light on that?
I can shed more light.
Oh.
I was not there when Rita, talk about that, but
I got
okay, is Rita speaking?
question that was specifically directed to me. I think the long and short of it is, first of all, yeah, can you hear me?
Okay,
Yeah, I'm
yes, we
not
can hear
muted.
you
Can you
now.
guys hear me?
Okay, maybe her network is just on and off, so we'll just, chill for her to. She just left, so it's like she's going to join back, but you can speak, definitely.
Okay, yeah. So I said I wasn't there when Rita said it, but I think I understand what Rita was trying to say. In comparison to some jurisdiction like the US, where the concept of trademark is largely tied to use in commerce. Nigeria is one of the countries I would say it's first to file, like first to get a registration, really.
Yeah.
And so well, I'm sure what I was trying to say is registration in Nigeria is very key to your trademark ownership, because for you to have a trademark, like you can have an unregistered trademark, right? The general principle of trademark lies in whether you're using a mark as a source identifier. And I think that is the essence of Section 8 of that Trademark Act. That trying to say give protection to persons that you might not have registration, but you have a trademark based on use. But one thing you need to look out for is if you are going to contest a trademark, as an unregistered trademark, but I have rights based on use over someone who has registered the mark, you are going to talk about like doing a litigation, like going to court to prove all of that. But in ranking of rights, most of the time, registered trademark will carry more weight than an unregistered trademark. Also, if the mark has not been registered, so it's if you're able to stop that registration, maybe like during the part where it has been published, you can file for opposition, you can oppose the mark. So at that level, you can rely on Section 8, right, of the TMA to say that's where you're bringing your basis for opposing this mark. You have been using the mark, you think you've acquired priority rights and prevent the registration. But if you sleep on that right and you have to go to court to litigate, you would have a very hard time, contesting with a registered trademark. Now, as opposed to, I'll just give a contradiction, as opposed to the US, where in the US, one of the bases in which you can even cancel a registered mark is on the basis of use. So use is the very first thing. Even the trademark examining attorney would likely not register a mark where it has been brought to the notice that so person. In fact, if you can't establish use in commerce, you don't get a trademark to start with in the US. So use is the beginning, the middle, and the end of your trademark in the US. So I'm sure that's what I was trying to talk about when she said in Nigeria, the whole first to use thing doesn't apply. Priorities are usually given to registered mark as opposed to unregistered mark. But Rita can speak more now.
I think definitely you covered most of what I was going to say. The basic thing when it comes to, can you guys hear me now? Because I kept going on now. Can you guys hear me now?
Yes, we can hear you.
Better. Great. Great. So the most important thing when it comes to trademark is just like Daphne has stated, use. But another C that you need to take note of is like you have to consistently use that mark. I know trademark has about 45 classes that you have to pick and choose. Now, can two brands with the same name exist? Yes and no. If it's not in the same class, then they can. But even if it's in the same class and it's going to cause a likelihood of confusion, whereby your consumers will mistake your brands or your mark for the other person's mark, then you have to reconsider that registration and fine tune. So I know what the registrar does is if there's a similar name out there, they just tell you to add a letter or two or just pick it up a bit so that the name in question, especially if it's a word mark, is not similar to an existing one out there. And like I earlier stated, and like Daphne has emphasized, the first to file principle is what we do here in Nigeria, which is why it's very important that we are considering trademark, you do a search. So you can do the free public search where there's no existing name or mark or word or letter in that you want to use for business. There you can go ahead to do the registry search or the regional search or the international search, as the case may be. But doing a search will help you save money and prevent you from result of registration or any opposition in the course of registering your mark. So, for instance, we had the prepare Apple Inc. case. So prepare because the pair was half written and the leaf was on the other side, and they eventually lost that opposition here. There are several other oppositions here, which will also shed light as to the importance of doing a first to file principle. That way, you're able to, if you feel that there's a similarity or there's a confusion or someone's going to confuse your mark, then it's best that you do that. You also need to consider the strength of the mark that you want to register, the case might be. Trying to remember something, but I think that basically covers it. I hope that answered the person's question. But if you did not, please send me a private message and I'll do my best to answer it. Thank you.
So this is the end of our Q&A session. So finally, before we go and before we, we definitely miss, the beautiful faces of our speakers. Which I'm seeing your face, move on, kind, behave yourself. So yeah, can we hear final words, concluding thoughts about intellectual property and startups? I'm sure some of our startup founders here, when you be hearing section this or section that, you'll be wondering like, what are you talking about? So that's why it's actually important to get an expert, a legal expert. It's not just somebody that can draft your agreements, but also somebody that actually understands the intricacies of your idea and how it works literally. So we'll start with OG. What are your final words for our startup founders and business owners in light of IP?
Well, I want to just emphasize, like you said, the importance of consulting an expert. But at the same time, startup founders themselves have to take interest in IP. You can't just leave everything to an expert because nobody knows your business like you know it. And nobody's going to know nobody's going to understand your goals like you will. So you have to understand IP. There's some small courses you can do online. Just know it, know the intricacies, and make efforts to protect your work. Include IP assignment clauses in your employment contracts, in your contract with independent contractors. Try to sign NDAs when disclosing non-protected inventions to investors and things like that. IP is important. I think we've done a good job in emphasizing just how important it is and the benefits it can have for a startup. So it's up to founders themselves to take it seriously and ensure it's adequately protected.
All right, Rita, how about you? Your last words. Sorry, your final words for our.
Okay, my final words. My final words. First off, from the very moment you consider idea, look at it as an asset that can generate consistent revenue for you for the duration of your lifetime, and even your heirs can inherit it. Up for consult with an IP lawyer or someone that has a knowledge on the interplay of IP and industry that you're going to be servicing. Do your registration documents. So while we make emphasis on non-disclosure clauses, we also have to make emphasis on non-compete clauses that protects you for a timeline. I know there's a law in the US that gives a timeline of 5 years that a former employee cannot go into the same line of business with you for that duration of time. So that's something that we need to. That is where someone was working with Paystack and then they left Paystack to go and create their own startup or fintech company, and everyone's like cheering them. So if you had put a non-compete clause in their employment agreement, that would have restricted whatever ideas or future plan they had. Same way we have the what's this case? The Bobo Juice case. Same thing. There's also a paint company who also went through that same process. If a former employee, replicated everything, and then, no one is saying anything. You also need to, have the right team. Think of ways to commercialize and exploit your startup, your business, your product, whatever it is. Don't see licensed parts of it and generate revenue to fund the new startup idea or business that you have. Always keep that back of your mind that resolution mechanism option that you prefer to use in the event of a dispute. And when you're looking at or asking your lawyer to draft your resolution codes, make sure that it gives you options and timelines, and also specify the kind of mediated or negotiated or arbitrated. So you need to have policies that protect you as a business person. So from the trade secret policy, which I mentioned, to the IP policy, to employee handbook. Also make sure it's in that particular jurisdiction. Also, if you're also going to be exporting or getting data, you also have to be data compliance, data protection compliance. You also have to consider cybersecurity issues, and also while you are delving into emerging areas, have like a sandbox on research purpose, and also use that as a platform to generate revenue from your business. But yeah, I guess that's all I have to say for this.
All right. Thank you very much. Okay, Daphne, let's hear from you.
Thank you very much. It's been a pleasure being here. So my final words to the startup entrepreneurs would be, I'll take you from start with what Uji said. Take interest in IP. I say that one of the reasons, so the IP climate in Nigeria is advancing, right? And it can be a lot better. And it starts with the innovators, the creators, and entrepreneurs. Take interest in IP. So don't just create something and say, oh, something called IP. I don't have money for that. Let it be part of your, when you take a legal framework, the same way you're interested when you're like doing like contracts and everything, make IP to, stand up for you. And, that brings me to the next point. The idea of knowing why we have this workshop or webinar is to sensitize and give more knowledge. And so that when you involve, you yourself can then get a legal expert like an IP lawyer, and they would say, okay, I know one or two things, so this is how I can tell this to an IP lawyer. You cannot do some things on your own, right? Involve your IP lawyer, and from the beginning. And I say this because one of the situations we have in Nigeria is people tend to involve lawyers when they have problems. The problems that you can save from the very beginning. If you're starting a company, let your IP lawyer be from the get-go, analyzing what needs to be done and how to have the effective IP strategy or portfolio, like we mentioned. It's very key and very important. Like, you can save so many issues. Understand that when it comes to IP protection, it lies basically in the laws that are in place and also with contracts, because there are some things like when Rita was talking about the non-compete, using the non-disclosure agreement to protect your trade secrets or unprotected IP creations. At the same time, too, even your employment contracts, right? Work for hire is something, I don't know, we didn't talk about it, but work for hire is not so developed in Nigerian copyright law. So this is a case where you will need to have a contract agreement to avoid dispute over the copyright ownership. So know that the laws and the contracts will be what will protect you. But until you yourself take interest and involve your lawyers, you might end up having problems instead of having you are creating solutions, right? When you innovate, let your innovations be the solutions. Let it not be let's not attract problem to you because you haven't done your due diligence. So, and that's very, very key. And I want to say that regardless of what sector or industry you find yourself, as technology is advancing and as we're having conversations about the metaverse, which is like, trending and coming up, a lot of business and startups are beginning to think in light of digital advancement as to how they can take advantage of technology. And IP is going to be like the next biggest thing, because we're already seeing like cases, for example, like even in the US, you see Hermes filing a case against the Meta Buckins, bag over their own. So that's a whole area. But my point is, if you are also thinking of advancing and how to make your business in the digital era, it is also important to have your IP lawyer, because there are some steps you must take. If you have a trademark, you might need to expand your trademark protection or classification, just like what these big fashion brands are doing in the US, so that by the time the metaverse fully expands, right, it would not be a case of they should have done this. So that should be your guiding to every entrepreneur out there. That should be your mantra, right? I want to do it right from the beginning, not I should have done this. And so, I wish you all the very best. And of course, feel free to connect with me on my social media platform ever available. It's Daphne Ekpe almost everywhere. Thank you very much.
Okay, thank you so much to our beautiful speakers, Daphne, Rita, and Augusta. We have been truly enlightened. And I really also hope that, our audience as well, I hope that, all of us have also been truly enlightened by the questions asked, the different, thoughts, different thought processes that have been, shared by our speakers. So this, comes to the end of this webinar. In case maybe you have, further questions, you can reach our speakers. Their names are. Give me a second. Okay, so we have Daphne, we have Augusta, we have Rita, and you can also reach out to Tech Hive Advisory as well in order to, connect you through. In case maybe they're behaving like big madams, don't worry, we'll talk to them for you. So this is the end of our session. Thank you so much, everybody, and have a great afternoon. Bye, guys.
Bye, everyone. Take care.
Bye, Daphne. See you. Bye.